unprecedented. The whole world was watching this case, and yes, I think he didn't want his decision debated in sort of the national press.
The grand jury decision 14 years earlier was not as it had been portrayed. Jurors had actually voted to charge John and Patsy Ramsey.
There is insufficient evidence to bring charges at this time.
But Alex Hunter, the DA at the time, declined to prosecute the Ramseys. Hunter would not return our calls.
A grand jury was called to review evidence in the case after the investigation stalled and voted to indict John and Patsy Ramsey on child abuse charges in 1999. Then DA Alex Hunter refused to charge the parents, citing a lack of evidence. Zandsberg says no one asked Hunter to release the indictment because no one knew it existed.
Boulder DA Alex Hunter died on Friday, less than a month shy of his 90th birthday. According to the Denver Post, the 89-year-old spent several days in Colorado hospitals, alert and cogent, saying goodbye to colleagues, friends and family. Then he picked 1:30 p.m. Friday as the time for medical staff to stop the life-supporting medicines keeping him alive. He drifted off and died later that evening.
I got nightmares in my head, I fear. Thoughts build up until I can't feel. My mind fills up into a creature, and it haunts me somewhere much deeper. I got nightmares in my head, I fear.
That's pretty brave, wouldn't you say, hitting the kill switch on the machines keeping him alive. Was Hunter also brave? Was it courage and morality? Was it moral backbone that guided his decision not to prosecute the Ramseys in October 1999?
No charges have been filed. I and my prosecution task force believe we do not have sufficient evidence to warrant the filing of charges.
What he didn't say, according to our partners at the Daily Camera, it was him, not the grand jury, who made that call.
And so once again, the question arises, was Alex Hunter right not to prosecute the John Benet Ramsey case? And I think one of the ways we can ask that question is looking at the entire arc of his life. What sort of decisions did he make? What kind of person was he? And what is interesting is that he thought he was right, and his son Alex Kip Hunter III said he was confident until the day he died of his decision, and it's actually in this final article from the Denver Post. In this analysis, I want to look at that and also examine 5 shockers about the Boulder DA. But before we get to that, if you haven't subscribed to the channel, please do. If you find this analysis worthwhile, please do hit the thanks button, and let's get started. Number 1, how he got elected to begin with. Did you know this? Hunter saw an opportunity to win an election, and he took it. It was always going to be a narrow margin, and he needed to find a way to get himself across the finishing line. And how he did that was by decriminalizing marijuana possession in the college town of Boulder. He did this in the 70s, 1973 to be specific, and it was practically a generation before the state of Colorado as a whole legalized cannabis for adults in 2012. According to the Denver Post, Hunter was first elected by a narrow margin in 1973 in no small part because he promised to stop prosecuting possession of marijuana as a felony, prompting University of Colorado students to vote for him in droves. That's according to Stan Garnett, who served as Boulder District Attorney beginning in 2009. But look at those words. He promised to stop prosecuting. He became a prosecutor. He became the district attorney on the promise that he wouldn't prosecute something. Now, I think what this demonstrates is a side to Hunter that was both interested in political expediency and arguably that he was a populist, or maybe a better word is a pragmatist. His politics and pragmatism would ultimately play a deciding factor in the fate of the Ramsey case. Number 2, he married 4 times. Now, what did politics and pragmatism mean in his personal life? Well, according to the Denver Post, the longest-serving DA in Boulder, I think he served from 1973 to 2001. Hunter married 4 times and had 5 children. Number 3, he went bankrupt before becoming DA. The Denver Post spares just a single sentence to describe one of Hunter's less spectacular achievements. He declared bankruptcy in the 1970s after a failed real estate venture left him $6 million in debt. So basically, this DA, before he became DA, was kind of in trouble. And becoming DA basically, I guess, in a way allowed him to rebuild his life. But I wouldn't say that he came into the district attorney's office with a heck of a lot of momentum. He sort of just slid by, just made it by the skin of his teeth, right? And also by using that ploy of not prosecuting marijuana possession. 14 years ago, the same paper shared a little more context in this area about this failed real estate venture. According to the Denver Post from 2011, in the 1970s, Hunter, the would-be real estate mogul, so that is what he was really interested in the 70s, was real estate. And his law partner, Bill Wise, now Hunter's chief deputy, bought property all over Boulder County, including one development called the Village of Camelot, where the streets have names like Lancelot Street, Guinevere Street, and Round Table Drive. Now, you might recognize Bill Wise as another prominent figure in the JonBenet Ramsey case. We have yet to deal with him as a peripheral figure. Back to the article, Hunter sold his interest in that property to a pair of developers who Hunter claimed never paid for it. That deal, piled on top of other investment missteps, left Hunter millions of dollars in debt. In 1974, when he filed for bankruptcy, 38 secured creditors and another dozen unsecured creditors were lined up to collect the nearly $6 million he owed them. Now, do you notice the date? He filed for bankruptcy in 1974. That was the year after he became district attorney. And I wonder whether people were aware when they voted for him about this filing. As early as September 1997, at least one publication speculated whether Hunter faced a conflict of interest in terms of his business deals and in terms of his position as district attorney, specifically while the Ramsey case was still in full swing. The article from UPI.com doesn't mince words. Ramsey lawyers DA own property jointly. Questions are being raised about possible conflicts of interest among lawyers for JonBenet Ramsey's parents, Boulder District Attorney Alex Hunter, and a lawyer advising police. Hunter and Ramsey's civil lawyer William Gray have been limited partners in a Boulder commercial complex since 1969. Hunter has a 3.6% interest in the property and Gray holds 7%. Bob Miller, an attorney advising police investigating the Ramsey case, and the Ramsey's lead lawyer, Hal Haddon, recently won a big civil judgment that could bring them $15 million in fees. Hunter tells today's Rocky Mountain News that the involvement is irrelevant to the Ramsey case and says, "I've never had one conversation with Bill Gray about this property, or about the Ramsey case for that matter." But the article goes on to note the entanglements do not break any ethics rules, but nevertheless raise a few eyebrows, especially when they play into a high-profile case that has netted no arrests in 9 months. And of course, the epilogue of this whole story would raise eyebrows as well. Number 4, Hunter's son died of a drug overdose. 11 years after the Ramsey case fizzled into nothing, Hunter's own child, John Hunter Hawk, died aged 20 of an overdose. It was referred to as the heartbreak of his life, and one that Hunter never moved past. That's what another son said. According to the Larimer County Coroner's Office, Hunter Hawk, that's Hunter's son, appeared to have died from an overdose after consuming alcohol, marijuana, and possibly prescription drugs. Now, I'm not sure if Hunter recognized the irony of his being elected on the ticket of legalizing marijuana only to have his own son die of an accidental drug overdose many years later. Some might say that's cruel and unfair to say that, but I don't think it's unfair to simply bring this up. Did Hunter's conscience prick him in this particular area, one wonders. At the time, the Boulder Daily Camera quoted a distraught Hunter saying, "We are one of too many parents, families, and communities that have been dumbstruck by the wave of drug abuse, particularly prescription drugs. Out of our tragedy, my family hopes that by showing our deep hurt and experience, there may be a way to boost awareness and to launch programs that effectively tackle the loss of our children. Now, I'm not sure if decriminalizing marijuana way back when was really helpful in terms of this end result. For today and tomorrow, please lock up your prescription drugs, Hunter said. To be careless in this regard is to be reckless. Now, as far as Hunter's own son is concerned, that postdates the Ramsey case. It was part of the future, but what about the past? Well, 5 years prior to the Ramsey case, Hunter's handling of the Gomez case would prove to be very portentous for the Ramsey case. According to the Denver Post, in 1991, an anguished and angry Paul and Jackie Gomez told the Post how Hunter's office had failed to get justice for their daughter, Brittany Sue Gomez. 6 years earlier, when Brittany Sue was 6 months old, her babysitter Roberta Martinez shook her so hard that the baby was left blind and retarded. Martinez pleaded guilty, served 4 years probation and 90 years in a Boulder halfway house. But when Brittany died, the coroner ruled her death a homicide, a result of shaking. Martinez was charged a second time, and that's with the same charge that the Ramsey grand jury voted on. But in exchange for her guilty plea, Martinez once again avoided prison. And this led to tremendous anger from the parents in terms of this babysitter essentially getting off scot-free. And at the time, Hunter said, I think it's fair for them to be angry at me, meaning the parents. They had a need to be angry at someone. And some still feel angry at how Hunter handled, some might say mishandled, the Ramsey case. And that brings us to number 5. Hunter kept the indictment secret.
First Amendment attorney Steven Zansberg says the court properly ruled that an indictment is a record of official action and must be disclosed.
Do you remember that Hunter only convened a grand jury after Detective Steve Thomas resigned, effectively putting a lot of pressure on him, because in his resignation letter, he literally accused the DA of mishandling the case, basically the DA's office. It was only because the governor intervened that Hunter finally relented almost 18 months after the 6-year-old beauty queen's death. Have a look at this AI overview. In 1998, a Colorado governor, Roy Romer, urged the local district attorney, that's Alex Hunter, to convene a grand jury. And that's after Steve Thomas's resignation letter. So they had to put pressure on him to act. And it wasn't only Steve Thomas's scathing letter, that wasn't the only one that Hunter ever received during his tenure. Another one also involving a law enforcement officer resigning, Kirk Long. He was the Boulder County undersheriff. He called Hunter gutless.
Zansberg says no one asked Hunter to release the indictment because no one knew it existed.
Is he obligated without anybody asking, though, to return or to make it public?
I think the grand jury indictment ought to have been presented in open court. It should have become a record of the court. And at that point, the public would have been made aware of it and would then have asked for it.
Now consider this. Given the fact that Hunter didn't want to convene a grand jury, it's hard not to wonder whether it was a fait accompli either way, that no matter what the grand jury decided, hadn't Hunter already made up his mind? Wasn't he clear on what he was going to do anyway? Well, then why have a grand jury to begin with? Then the grand jury is just a sham, a pretense. It's just going through the motions, kind of like the Ramsey ransom note. It's something that's bogus. And this grand jury went through the motions for 13 months, and they didn't throw up their hands at the end of it and say, you know, we just can't decide between the intruder theory or whether the Ramseys did it. They unambiguously did decide. They clearly heard the evidence and decided on it.
Brennan wanted to get a hold of the grand jury's decision himself. He went to court.
I don't think most of us could believe it. He won, and they unsealed those grand jury records in 2013, and it was quite illuminating.
Indeed it was. So what do I think of the way Alex Hunter handled the grand jury investigation? Well, I think he was wrong to say that there was not sufficient evidence. I mean, factually incorrect and legally incorrect. That's my opinion. If there is a case where you're going to talk about insufficient evidence, the Ramsey case should be at the bottom of the list.
17 years after John Bonet's murder, the court released 4 true bills or written decisions from the grand jury. The jury recommended indicting John and Patsy Ramsey for accessory to first-degree murder.
I've seen cases like the Scott Peterson case, Patrick Frazee, the Idaho 4 case that saw convictions based on far less evidence, and arguably these were far more compromised crime scenes as well.
Lance, he's telling you that they went to court for 3 reasons.
Those reasons were to gain information about an unsolved murder, Mike, to correct the misimpression that a grand jury did not return a true bill, and to establish the principle that when a grand jury returns an indictment, the public is entitled to see it.
I personally think Hunter was wrong to mislead the Boulder community into thinking the grand jury had acted in a way they had not. In my opinion, if he was so confident of his decision, he would not have hidden the truth of the true bills in a statement that created a wrong impression, which effectively misled the community that he was elected to serve for 13 years. That seems to me to be a betrayal of trust.
I think the grand jury indictment ought to have been presented in open court. It should have become a record of the court, and at that point the public would have been made aware of it and would then have asked for it.
If Hunter was so confident, he could have had the confidence to be more transparent, saying in general terms that the grand jury had voted to indict, but that he had overruled them. I don't think he was as confident as many assume he was, but it's possible he didn't reveal the indictments in order to protect perhaps one individual in particular, and perhaps he felt the Ramseys deserved similar protection.
It's extremely unusual that a district attorney not sign an indictment when a grand jury returns a true bill.
Was the district attorney doing something out of the goodness of his heart because people deserved protection? I'm not convinced. I think the bottom line is what happened here in this case and with this district attorney. The bottom line is that it was highly, highly irregular.
The grand jury had voted to indict. Are they referring to a third person?
It does appear that the theory they were looking at assumed that maybe someone other than the 2 Ramsey parents had been involved in what happened.
Well, I'm not going to take it further than that, but our condolences go out to Alex Hunter's family. This can't be an easy time for them. Thank you for listening, and I'll see you guys next time.